Case number 18-15-4261. This is Capital One Bank versus Amitha Sellers. The matter is before the court, set on for review on today's date. Your appearance for Capital One, please.
Good morning, Your Honor. Sazan Barta, P65425 on behalf of the plaintiff.
Thank you, Ms. Barta. Good morning to you. If I have Ms. Sellers with me, say something at this time, please.
This is Amitha Sellers here.
All right, thank you, ma'am, and good morning to you as well. So I sent this over for review. It looks like there was something that the parties were looking at. I have some numbers here, and counsel, update me on what's going on.
Yes, I think the last time we were here on May 11th, you released the garnishment. I think you made all your decisions on those orders on that day, but you set the review date just to see if we were going to file a satisfaction of judgment if the garnishment payments took care of this. I believe the defendant said there was $1,800 withheld, but we didn't know for sure. Well, it looks like $1,293.63 was withheld, which left a balance of $282.70, which Ms. Sellers contacted her office and actually has a payment plan of $80, $80, and $40 to take care of this. And then the satisfaction of judgment will be filed as soon as she does that. So I don't think there's anything for the court to make a decision on this morning.
All right, Ms. Sellers, that sounds about right to you, ma'am?
Yes, it sounds about right to me.
All right, well, you're near the finish line here, and as you complete those items, and the court will receive a satisfaction, and that will close this case out, ma'am.
Okay,
So,
thank you.
All right, I wish you well, and I'll be waiting on the satisfaction, so get those last payments in, and then this is all over with.
Okay.
All right,
Thank you.
ma'am. Counsel. Thank you, Mr. Barter.
Thank you, Your Honor. I have another one at 10, but I will wait.
All right.
And I also sent you a chat, Mr. Barta. I had a question.
I'll reply to that right now.
Okay, thank you.
All right, thanks.
I have someone from Midland here. Any counsel for Midland Funding?
I'm Shay Smith.
Ms. Francis is here.
Are you the attorney from Midland Funding?
No.
I'm not asking for you right now. Do I have the attorney from Midland Funding?
I'm not on Midland, I'm on Hirschberg.
All right. I know that Mr. Smith is here on Midland. That's why I'm looking for the other side. We called that early. All right, Ms. Francis, which matter are you on again?
I have 313, Your Honor.
All right, do I have Yancey here? Last name Yancey? All right, so I'm waiting to see if that person's gonna come in, counsel.
Thank you. Judge, who is the attorney for Midland?
Let me take a look at that. Just 1 second here. Looks like I've got Mary Jane Elliott on this.
Okay, I'll check with them really quickly.
Thank you.
Thank you.
Mr. Varda, which 10 o'clock matter are you on, sir?
Your Honor, I have portfolio recovery versus Tiffany Marshall.
Okay, I do have that in front. Ms. Marshall, are you out there anywhere? I'm going to give it a few more minutes, counsel, and I'll check back on this.
Thank you, Judge Coleman.
Yes, we want to be here. No, they just got it on board.
It's crazy.
Didn't feel that bad yesterday.
Oh, my unit mouth. Hey, Mr. Chuba, what case are you on, sir?
Morning, Your Honor. Midland Funding and Smith, 032.
All right, this is case number 12-1000-32. This is Midland Funding LLC versus Chase Smith. The matter is before the court on the filing of objections to a writ of garnishment. The garnishment relates to the Michigan Department of Treasury. The record should further reflect in this matter that a judgment was entered in this case initially on the 12th of June, 2000, the 11th of June, 2012, for $1,439.05. That judgment was renewed on the 10th of May, 2022 for the same amount. Your appearance at this time, counsel for Midland.
Good morning, Your Honor. Brian Truba, appearing on behalf of the plaintiff Midland Funding. My P number is 61752.
All right, thank you, counsel, and good morning to you. I believe that I have Mr. Chase Smith on this Zoom. Say something if you're there, sir.
Yes, I am absolutely here. Yes, I am.
Thank you, Mr. Smith, and good morning to you, sir.
And good morning to you, Your Honor.
All right, this is, as I've stated previously, sir, this hearing is set up because there's an objection to a writ of garnishment. And I looked at your objections and you didn't check any of the boxes, but you did indicate I was not sure because I did reside at address knowledge of garnishment was with IRS.
Your Honor, I'm going to be, let me be verbatim so you can verbatim about that. There's a lot of reasons about that, it wasn't enough paper or enough writing to put on that paper for my objections. I don't have just one objection that Midland Finance sent me a copy of. I've been trying to resolve this through Midland Financial, and Midland Financial is not interested in the justice. They're interested in just money as the debt collector. This is not my debt. I never lived at that address. I don't, the account that they're speaking of, I've never had. I was a victim of identity theft 10 years ago, along with with the IRS where someone filed taxes in my name. Midland Funding sent me an affidavit. I sent them back to them in regards to the fraud case. And the next thing I hear is that I get a thing from them again with this matter.
All right. Counsel?
Judge, with respect to the objection itself, the defendant's statement appeared to be attacking the underlying judgment. As the court's aware, MCR 3.101K1 prohibits that kind of objection. Objections can't be used to attack the validity of an underlying judgment. With respect to his other statements, Your Honor, we did send him an affidavit of ID theft on February 1st. We did not receive it back. What I can do is I'll send him another one.
Sir, did anybody interrupt you with, let me stop you, counsel.
Yeah, yeah.
Sir, did anybody interrupt you with laughter while you were talking?
Pardon me?
Did anybody interrupt you with laughter and chuckling?
I didn't interrupt anybody, but it's just amazing to me that they didn't get this affidavit back.
So you didn't make a sound while this gentleman was talking?
Pardon me?
So you didn't make a sound chuckling while this gentleman was talking?
Oh, I chuckled, yes, because this is amazing to me.
Okay, well, it's going to be even more amazing to you because you sound like you're opting out of the hearing. That's what it sounds like you're doing. I won't let anybody disrespect you. I don't know why you think you could disrespect other people.
Well, I'm not disrespecting anyone, but I feel disrespected and no.
Okay, well, I just muted you, and in a moment you'll be completely excused from the hearing, because what you would like for me to do is to hear you and then not listen to the other side while you interrupt. That's what you like. That's not how it works at court. Mr. Tewin, you had something else you wanted to say, sir?
Yeah, irrespective of the defendant's feelings, Your Honor, I have a policy. If he thinks it's identity theft, I'll send him another affidavit of ID theft. We did not get, if he filled it out and mailed it back to us, we didn't get it. So I'll send him another one out today.
All right, thank you. I've heard the objection raised on the garnishment. This judgment has been in force for more than 10 years. I don't see a motion to set the judgment aside. That is how you attack the underlying judgment if you believe that it is improperly entered. You can't attack the underlying judgment in the context of a hearing on a writ of garnishment. The writ of garnishment is attacked by raising issues like I filed for bankruptcy, I have an installment payment plan, the judgment has already been paid. Those are the kind of issues you raise to object to the judgment. It sounds like Mr. Smith is objecting to how the judgment was entered and not to the enforcement of that judgment. If he's going to object to how the judgment is entered, then he has to file a proper motion to do that. To the extent that Mr. Smith has raised the issue that this arises out of identity theft, then certainly that is an issue that should be addressed, and it is addressed by the filling out and the presentation of an affidavit. Mr. Smith says that he already did that. The plaintiff says they have not received the document. So Mr. Truba has indicated to this court that he is going to resend that document, and if Mr. Smith fills that document out and sends it back, that he will have that reviewed. And if there is an establishment of fraud in this case, then of course, there should be no obligation that inure to Mr. Smith. Everybody's on the same page with that. Nobody believes that if you're a victim of identity theft, that there should be a judgment against you. But that is something that has to be established, and there are ways of doing that. As it relates to the objection to the writ of garnishment, the court will deny the objections because the objections address whether or not the judgment should have been entered and not the fact that the judgment is in fact in place. One is called pre-judgment. The other is called post-judgment. This is a post-judgment effort. This is an effort to collect on a judgment already entered. If Mr. Smith believes that that judgment should not have been entered, he does have the right to file a motion to try and get that judgment set aside. But as long as that judgment is in place, the plaintiff has the right, in fact, to pursue collection remedies. And that's what this case is about at this time. I will deny the objections and allow for the release of any withheld funds to the plaintiff. I will also set this matter over for a follow-up hearing because I'd like to know what happens as it relates to the affidavit. So I'm going to set it over for 30 days and I'll review the matter at that time based upon the filing of the affidavit. So the next action date in this matter is going to be
July, you said 30 days, July 28th.
July 28th, 2022. And that's going to be at 10 o'clock a.m. The same Zoom number that was used today is the date can be used at the next action date as the court reviews what happens as a result of the affidavit regarding fraud in this matter. Because indeed, if there is identity theft or something along those lines, then that should get worked out, and Mr. Smith should not be obligated. That is my determination in this matter. I do wish both sides well. Good day to you.
Judge, can I ask the defendant his address just to make sure we get it to the right location?
Well, he filed something here. But let me do this. I'm going to put you in a breakout room. Because I'm not going to have any of the interrupting stuff and the disrespect. So hopefully you can deal with him in that regard, and it won't cause a problem. But if not, then you'll
Okay.
find a way to deal with these issues.
Okay,
Right,
thanks,
so-
Your Honor.
All right, thank you. All right. Let's deal with, so I'm going to deal with portfolio right now. This is case number 21-44287, Portfolio Recovery Associates LLC versus Tiffany Marshall. The matter is before the court on the filing of objections to a writ of garnishment. And I have received the plaintiff's response to the same. Just one moment, counsel. So the objections filed in this matter, I should indicate the defendant does not specify any particular objection. And I should also indicate that the garnishment relates to the Michigan Department of Treasury. And then finally, that this judgment was entered on the 27th of October 2020 at 9:34 for $934.01. All right, counsel, your appearance regarding this matter, sir.
Good morning, Judge Coleman, Cezanne Barda, P65425 on behalf of Portfolio Recovery. Today is the date and time set for defendant's objection to a Michigan Department of Treasury tax garnishment. We received $222 on that garnishment. Defendant having failed to appear and having failed to check a box, I would ask for defendant's objection to be denied at this time.
All right, under the circumstances where this matter was set up for 10 a.m., it's 10:14. The court reviewed the objections. Does not appear to be any objection. Moreover, the defendant has not appeared for the hearing. I will deny the objection, find that they're invalid, and immediately release any funds withheld to the plaintiff at this time in so order.
Thank you. Have a wonderful day, Your Honor.
Likewise to you, sir. And thank you for your patience, Madam Counsel. This is case number 10-110-313. This is Hirschberg Acceptance versus Shanita Yancey. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered by default on the 21st of July of 2010. Looks like that judgment was renewed on here on the 20th of July 2020. The judgment amount is $1,212.43. The objections are here relates to Highgate Hotels. Counsel, your appearance regarding this matter, please.
Good morning, Your Honor. Navjot Francis, P72322 on behalf of Plaintiff's Attorney of Record.
All right, thank you, counsel, and good morning to you.
Good morning.
I looked at the objections here, wherein the plaintiff, strike that, the defendant checked box F and indicated I did not receive the judgment, unable to retrieve file, miss hearing, late for a job or something along those lines. It doesn't seem like any of that is anything that relates to the garnishment itself. And it doesn't appear that the defendant has appeared on today's case. All right, go ahead, Counsel. Anything?
Thank you, Your Honor. Yes, defendant's objections as listed are invalid. I'm not sure if she's trying to attack the underlying judgment or actually what she's arguing, but attacking the underlying judgment is not allowed under the court rules through an objection to garnishment. So her objection should be deemed invalid.
Ms. Francis, I will, under these circumstances, determine that the objections are invalid. I will immediately release any funds to the plaintiff. And I'm signing an order consistent therewith. And the record should reflect again that the defendant did not appear for the hearing on top of the other things that have been mentioned. All right, thank you, counsel. Good day to
Thank you, Your Honor. You as well. Thank you.
Okay.
Good morning.
Hey, Deborah.
Good morning, Deborah.